Friends, in this lecture, you will learn about two topics. One is Scheduled Bank and second is Banking Law Amendment Act 2012. So first, let's learn about Scheduled Bank. What do you mean by Scheduled Bank? Scheduled Bank in India, as per Section 2E of RBI Act, Section 2E of RBI Act, a scheduled bank means a bank whose name is included in the second schedule of RBI Act 1934. A scheduled bank should satisfy the conditions laid down in Section 42 in bracket 6, which includes paid up capital and reserve requirements of not less than rupees 5 lakhs. Satisfaction of RBI that the affair will not be conducted by the bank in a way to jeopardize the interests of the depositors. So it is laid down in Section 42/6. It may be a state cooperative bank, a company defined in Companies Act 1956, which is now revised by Companies Act 2013, an institution notified by central government, and a corporation or a company incorporated by or under any law in force. That is, commercial, rural, or many state cooperative banks are classified as scheduled banks. So, state cooperative banks, a company defined in Companies Act or under any law in force. So, the commercial, rural, and many state cooperative banks are classified as scheduled banks. A bank that is not included in the second schedule of RBI is called non-scheduled bank. Clear? So now we'll move to second topic of this lecture, that is Banking Law Amendment Act 2012. Banking Law Amendment Act 2012 was notified on January 18, 2013. To amend the Banking Regulation Act 1949, the Banking Companies Acquisition and Transfer of Undertaking Act 1917, and the Banking Companies Acquisition and Transfer of Undertakings Act 1980. So you can conclude that to regularize and amend these three acts, namely Banking Regulation Act 1949, Banking Company Acquisition and Transfer of Undertaking Act 1970, and Banking Companies Acquisition and Transfer of Undertakings Act 1980, to amend all these three acts together, the Banking Law Amendment Act 2012 was notified. It was notified on January 18, 2013. So what are the salient features of it? 1. Enhanced regulatory power to supersede Board of Directors. In consultation with the central government, RBI can order to supersede the Board of Directors up to 6 months. It can be extended to a maximum of 12 months. So, the first point is, as salient features, enhanced regulatory powers to supersede Board of Directors. In consultation with the central government, RBI can order to supersede Board of Directors up to 6 months, and it can be extended to maximum of 12 months. Second point, inspection of associate enterprise. Section 29A of this Act confers power upon the RBI to call for information and records relating to a business of the company and or its associate enterprises. So what is second point? Inspection of associate enterprise. Section 29A confers power upon the RBI to call for information and records relating to business of the company and or its associate enterprises. Now, third point, investment limits. As per amended section 3 of the Banking Companies Acquisition and Transfer of Undertakings Act 1970 and 1980, nationalized banks can issue bonus shares and rights issues and increase the authorized capital with the approval of central government and RBI without being limited by the ceiling of a maximum of 3,000 crore rupees. So the third point is about investment limits. As per this, the law was earlier law section 3 of Banking Companies Act 1970 and 80 was amended. Now nationalized banks can issue bonus shares and rights issue and increase the authorized capital with the approval of central government as well as RBI without being limited the ceiling of maximum rupees 3,000 crores. So the ceiling of rupees 3,000 crore has been removed. Next is fourth point, the salient feature of this new act. Depositor Education and Award Fund. Depositors Education and Awareness Fund, that's DEAF Fund. Section 26A provides to establish the Depositors Education and Awareness Fund to create awareness among the customers. So what it says? The Section 26A of this Act, Amendment Act 2012, says about establishing the DEAF Fund, Depositor Education and Awareness Fund, to create awareness among the customers. So next point is 5, acquisition of shares and voting rights. Prior approval of RBI is mandatory to hold 5% or more of share capital or voting rights in a banking company. The RBI shall take a decision on the application within 90 days. So what is the fifth salient feature of this new act? Acquisition of shares and voting rights. Prior approval of RBI is mandatory to hold 5% or more share capital or voting rights in a banking company. The RBI shall take a decision on the application within 90 days. 90. Next is 6 point, cooperative societies. It is about cooperative societies. The cooperative societies should mandatorily obtain license from RBI to carry on the banking business. Next feature is about penalties. This is under the Amendment Act 2012. It increases the penalty for contravening the provisions of the Act. Now these are 4 points. First is for providing false information to RBI, the penalty would be INR 10 million. If any bank or banking company provides false information to RBI, the penalty of Indian rupees 10 million would be imposed. Second, or failure to provide account books or any requested information to RBI, the penalty would be Indian rupees 2 lakhs, and if the default continues, then an additional fine of rupees 50,000 shall be imposed. Right? So what is the point? The failure to provide account books or any imposed information to RBI, the penalty would be rupees 2 lakhs, and if the default continues, then an additional fine of 50,000 rupees shall be imposed by RBI. And third point is defaults in complying with any of the requirement obligation under the Act, a penalty up to rupees 10 million or twice the amount involved in such contravention, whichever is more. So default in complying with any of the requirement obligation under the Act, a penalty up to rupees 10 million or twice the amount involved in such contravention, whichever is more. It's to be imposed by RBI. And the fourth point is regarding penalties as per the new Amendment Act is failure to furnish account books or any requested information up to INR 2 million. So, if any bank or banking company fails to furnish account books or any requested information, the penalty of 2 million rupees, that's 20 lakh rupees, will be imposed. The next point is 8th, voting rights. Private sector banks. It increases shareholder voting rights from 10% to 26% in private sector banks, making investment attractive for foreign players. So for private sector banks, it increases shareholders voting rights from 10% to 26% in private sector banks, making investment attractive for foreign players. And for public sector banks, it enables the government to raise voting rights in public sector banks to 10% from the current 1%. So now do you understand? For the private sector bank, the voting rights from 10 to 26% is increased. And for the public sector bank, it is increased from 1% to 10% in case of shareholders voting rights. So now in this lecture we have learnt about scheduled bank, what are the scheduled banks, and a detailed amendment features about Banking Law Amendment Act 2012, which is a compilation of amended acts of Banking Regulation Act, Banking Companies Act 1970 and 1980. So friends, I hope your knowledge is enriched after listening to this informative video. To continue with our channel, please subscribe